Hello, everyone. This is Ellen Zimiles from Guidehouse Consulting. It's really great to be here today. I am joined today to talk with several wonderful colleagues to talk to you about the practical considerations of the new money laundering law, the Anti-Money Laundering Act of 2020. I run Guidehouse's financial services segment, and I spend every day in the financial crime space. And with me are my other comrades in arms in the financial crime space. And it's really a joy to be able to do this. Guidehouse and Pillsbury Winthrop have gotten together for this, and it couldn't be, really a more fun and great group to work with. And I'm actually a knowledgeable group, and the people who know how to actually look at the money laundering statutes and make it very practical for you and sort of figure out how you take what's on paper and make it work for the institution. So with that, I'm going to ask Alma Angotti to introduce herself. Alma?
Hi, Ellen. I'm Alma Angotti. I'm a partner here in financial services, and I'm also delighted that you've decided to join us today, and we think you'll find it very useful.
Great. And then I'll just go across the row here. Cassie Lentchner.
Thank you so much, Ellen, and I'm delighted to join everybody here today. I'm at Pillsbury Law Firm, and I come most recently from the New York State Department of Financial Services and have been working in-house in both law firms, government, and major financial institutions on financial crimes compliance for the last several years. And it's delightful to be on a panel with such knowledgeable guests.
Great. And then last but absolutely not least, we have Deborah Thoren-Peden.
Hi, very nice to be with everybody today. Thank you so much for joining us. I'm a partner at Pillsbury Winthrop Law Firm. I'm a co-chair globally of the payments team and a variety of other teams at the firm. Perhaps more relevant to this, I spent 10 years in-house at a bank where I was the BSA attorney for the bank, and then I've been GC of a couple of payment companies where I also got to be basically the BSA officer at the same time as being the GC. But really pleased to be here today. Thank you.
And so on our next slide, we can take you through the table of contents, and Deborah's going to kick this off and giving us sort of the background and purpose of the Act.
Okay, so the Act certainly came about in an interesting way. It certainly had been considered for a while, and then I think in December, President Trump vetoed the bill, but then it went back before Congress, and on January 1st, it was enacted over the veto. The law itself is, I think, about 1,700 pages long. A large portion of it addresses defense issues. And in fact, the entire title is called the National Defense Authorization Act for fiscal year 2021. Pretty exciting. But within that act is the Anti-Money Laundering Control Act of 2020, as well as the Corporate Transparency Act, which is really the one focusing on beneficial owners. Obviously, this will be coming into effect. Some of the provisions are already in effect. Some of them won't be in effect for a while, and there'll be more outreach. But at a high level, what Congress was really trying to accomplish was they wanted to, in many ways, sort of modernize, I think, some of the processes in terms of what financial institutions and others covered by the BSA have to do. Recognizing that information sharing is important. So they're looking at improving information sharing. And actually, one of the things is even piloting a scenario whereby there could be more information sharing within international banks and many other things. They're going to go back and look at some of the current BSA laws and requirements and reporting requirements to see if some of them need to be adapted. The Act is very cognizant of the changes that have come about with AI and other technological advances, and is certainly focused on ultimately enabling use of those systems and embedding those systems into AML programs for those covered, but also at the same time recognizing that the systems really need to be risk-based, which has been true for a while, but I think this new act really sort of brings that up a number of levels in terms of the focus on risk-based programs. As I mentioned, there's going to be new beneficial ownership reporting requirements, which is definitely a different twist, and in a way it's a bit of a throwback to what people wanted, where FinCEN will ultimately be the recipient of the registrations. And also they're setting up new databases at FinCEN for that purpose. But that's sort of the overall purpose of it. Ellen, do you want to sort of talk about the 5 different areas that the law breaks down into?
Sure. I'm going to go through them, but just at a very high level. And this is kind of the cheat sheet for the act itself and how it gets broken down. And so the first one is really has to do with what they're going to do. It requires the regulators to establish certain exam priorities. It goes through what there are issues as what is required for the government to do. And then there are the next one, Title B, is about modernizing the AML and CTF reporting system. This has been back and forth a long time as to which way to go on that and where we should go. And then there'll be a lot of studies sort of put into place with that. The next one is improving the communication and oversight processes. We then go to establishing and this is a big one, the beneficial ownership information reporting requirements. You can hear a lot about that. Cassie, I think, is going to take us through that. And that is really, I think, one of the biggest changes that the law makes. And then the last one, Section E, is really sort of all different miscellaneous things that they kind of threw in here. And the big, if we go to the next slide, the big question on a lot of this is, when do these things go into effect? We gave a little bit of a highway of how they go into effect. And you can see this. The only one that I would say is the one that we are sure about is January 1, 2021. There are actually certain things. And if we go to the next page, if you can just go to the next slide, we see there are certain things that actually have gone into effect, that the expanding the definitions, establishing a FinCEN exchange, certain things that are listed there absolutely are in effect as of today, as of January 1st. Then there are all these other things, and we gave dates there, but likely many of them are really contingent on promulgating certain regulations, getting approval of various different entities, having a study done. I think some of these may go out, some of these may get extended, but we gave a shot at sort of based on what it says in the statute of what the dates are that certain things will go into place. But just be aware, as I said before, these are really contingent on other factors. So those kind of pages give you a summary and give you kind of like the, just an overall view of things. But from that, now we're going to just go forward and get into the, we're having a poll question. Alma, were you going to run to the poll question? And we'll have a few of these through the program today, which will help us, frankly, guide some of our conversation with you.
Sure, I can ask the poll question. This one is, which of the following AMLA provisions do you think your institution will benefit the most from? Increased information sharing, the ability to share compliance resources, access to the beneficial ownership database, which Cassie will talk about later. Is not clear how unlimited that will be, and streamlined SAR and CTR requirements. Oh, so we have a slight winner over the information sharing for the beneficial ownership database. And a lot of people are hoping for streamlined SAR and CTR requirements. I have a feeling it's not going to be as good as you think it is or hope it is, but that's great. Thank you so much for participating. Ellen, I'll send it back to you.
Great. And so then we're going to just go into the next section here. And so why don't we just get started with that? Is that, Alma, is that you or Cassie?
This is just a summary page of kind of the practical considerations. As Ellen said, a lot of these won't go into effect right away, but there are going to be some things that we think you can start thinking about. And some of those things may have a long lead time for your internal processes, so it's a good idea to start thinking about them now. The communication, particularly technology, which Ellen's going to talk about in some detail, the beneficial ownership, again, more questions than answers for that one, and the SAR and CTR reporting. I think Deb's going to talk about the penalties and whistleblower provisions, and that those do take place immediately. So that is something to worry about. And then there'll be some compliance enhancements that you may need to start planning for based on what we think is coming down the road.
And with all of these things that are coming down the road, I think it's important for everybody to think about how this could impact their institution and whether they want to weigh in on the comment process. This is going to be the opportunity. These are significant changes to the overall landscape of AML regulation in the United States. And there's a series of studies, regulations, comment periods. We're going to talk about some more that everyone who is interested will have the opportunity to submit comments and to have their views heard, and to take this opportunity in this year to try to shape the rules to make them work for their institution. And the more information or data that's shared with government, I mean, FinCEN and Treasury, they're looking for data on some of these and looking for data to try to make sure they're framing these rules correctly and appropriately to accomplish the mission they're trying to do. So this is really an opportunity for people to take a look at their program, think about how these changes could make it better and make the AML regulation better, and think about comments to submit.
And Cassie, I would imagine that some of the trade groups are going to be putting together things, whether it's the ABA or IAB or various different organizations are probably going to be requesting, comments from the membership to do that. And that it may be that there's some that an organization may want to put forth themselves, but then others that you might be able to get some force through some of those trade organizations.
I think that's absolutely right, Ellen, and I think that these are great times for people to come together with other interested parties, like Pillsbury and Guidehouse are doing today, to try to think through these issues, think about where it's going, and have a smart and savvy regulatory landscape going forward.
Great.
Cassie, do you want to talk a little bit about the communications, what's actually required or what seems to be required by the rule with the regulatory industry communications?
Absolutely, and I think this is really an important part of the rule. And Deb, I think you also have wanted to talk about some of them. So I think that in particular, it's important to understand that the goal of Congress in passing this law was largely to actually increase information sharing and communication. And in fact, the joint explanatory statement on the Conference Committee in Congress specifically said, in particular, the Conference Committee requires more routine, systematic coordination, communication, and feedback among financial institutions, regulators, and law enforcement to identify suspicious activities and better focus bank resources to AML tasks, which will likely increase regulatory and law enforcement outcomes. I think that's music to the ears of a lot of financial institutions. Deb, you want to talk about some of the particular
and one of the things that I think is really good is one of the things that I think will be started fairly quickly is FinCEN or Treasury in conjunction with input from certain other agencies is going to think through the priorities that should be in place in terms of AML and BSA and terrorist financing, and come up with a list of, ultimately they will come up with a list of priorities that will be published, and then for institutions subject to the BSA, they will be expected to embed them into their own policies and procedures. But I think that will be helpful because I think there's a recognition, for example, that it's going to be more useful to spend more time and effort on high-risk customers rather than on low-risk customers. Things like that will be considered as part of that process. As Cassie mentioned, there are certainly a number of information sharing arrangements that are going to be happening as part of this process. FinCEN's got, there's a section on doing info sharing with tribal authorities. There's new extensions of efforts with foreign financial intelligence unit liaisons. FinCEN's going to have domestic liaisons. They're going to have an establishment of a BSA information security officers to interact with other regulators as well as with the banks. So there's going to be a lot of information flow. Well, the one area of information flow that people might have a different view on is they've also included new sections on obtaining foreign bank records from banks with U.S. correspondent accounts. And in addition to, continuing to have a right to get those records at the correspondent account or at any account at a foreign bank, they have certainly increased the penalties as well for failing to comply. So that is one of the things that is now in effect, but it is info sharing, but I think it's info sharing more back to the government rather than forward info sharing with the others. Cassie, anything you want to add to that?
Well, yes, and thanks, Deb. And I think that also it's important to understand that there's information sharing and communication and clarity mechanisms that are being established for the financial institutions. One of the priorities is for FinCEN to create a FinCEN information exchange network in which that would be gathering information and giving financial institutions feedback on how well did their SARs do? Did this actually help law enforcement to prioritize significant matters? I mean, how does the SAR, what is the results of the SAR reporting? Not by particular names of particular actions necessarily, but the FinCEN, but to actually make sure that institutions know how they can, how their reported information is helping the battle against money laundering. There also is a plan to establish a no action letter process where institutions will be able to write and get clarity on the requirements.
Hey, Cassie, on those last two, it seems like there's probably going to need to be more resources given to FinCEN and Treasury and the law enforcement agencies to actually do all of this. And so I think that's what we haven't, we saw this, but then there's going to have to be some appropriations given to some of these to be able to, to be able to give back feedback to all the financial institutions on the value of their SARs is going to take a lot of manpower to do. And
Absolutely.
That's one of the things that we have to see whether they can accomplish this. They certainly couldn't accomplish it with what the number of people they have currently. And so how many people they're going to get, how many, additional resources to do some of this, I think will be interesting to see. And I did want to ask Deb on that piece on the information sharing, which was really the long arm kind of jurisdiction issue for the correspondent banking. Mm-hmm. How do you think that the foreign governments are going to feel about that? And, Cassie came from a Swiss bank at one point. How do you think that some of these other jurisdictions are going to take to that?
I am sure that they will not embrace them with glee. You'll phrase it that way. But just like any other time, I'm sure there may be some issues in terms of, whether they've got appropriate jurisdiction or the like. But it is interesting because one part of the law basically states that it is that they may not have their subpoenas quashed merely on the basis of someone claiming that would potentially violate foreign privacy laws, which is sort of an interesting shift, and that's literally one of the sections in our new law. And they've also increased the penalties. So if you're on the U.S. side, there are extensive penalties, but they've got rights to take penalties against the foreign banks. There's also a prohibition on notifying parties that there's been such a subpoena sent out, and actually some pretty draconian penalties if somebody blows that notice, almost akin to, giving notice of a SAR report. Not quite that high, but it's pretty high in that sense.
Yeah, so we'll see how that works out and how, whether that gets litigated after this and whether the ability to actually do this is litigated, following the imposition of that.
Right. So I think the correspondent bank provisions, certainly may impact some people, to be sure.
Right. All right. So our next slides are, here we go. Oh, polling question. Sorry. We did. We're on our technology issue. So one of the things that they did, and Deb and I were going to talk about this, is that they're putting in innovation officers and in the different agencies, which is really, which is a great thing. The OCC has an Office of Innovation. They're going to sort of include this. One of the, I think, the issues that has been in the past is that even though there may have been an innovation office, the examiners on the ground may not be in the same place as the innovation office is, or that they may not have the same background or the same ability or willingness to sort of accept some of the innovation that financial institutions are doing. Although we did see more and more this going forward. We had used machine learning in various different situations and had, pretty good acceptance of that by various different regulators. But there's been a back and forth. It hasn't all gone quite so smoothly. So, I think we'll see a little bit more of that. But they are trying to, this is basically, an attempt to say, look, we want you to do things the right way. We've heard how much complained about the amount of work that gets done that's really not productive and is extremely costly and actually can take you away from working on things that actually could be very, productive for you. And so this is, I think, the attempt at doing that. And how this actually gets played out and how it gets implemented might vary from agency to agency. But I think that this is clearly the recognition that the government or the regulators have heard what the banks and the financial institutions have said and are willing to do that, and an appreciation of how much fintech there is out there and how much fintech has, progressed. So I think, I'm looking forward to all of this and to see how this works. It could be a very exciting time, and perhaps at some point in the future, the time of having a transaction monitoring system that really gives you 90-something% false positives and really isn't effective, but is what was required, may be gone, and maybe there may be a better, more effective and more efficient way to do the work that the financial institutions have had to do so far. Okay. Here. Cassie, were you going to do that next one, or Deborah?
Sorry. The polling question?
Yeah.
I think it's me.
Okay, go ahead.
Believe that your institution currently has the appropriate systems and technology to take advantage of the AMLA's focus on increased automation and emphasis on innovation. Kristen, can you go to the survey so we can see what people think? All right. I think you may need to X out of the pop-up to see the slides again after you see the poll. It depends on your system. So most people, well, it's not, we definitely have more people say they're not ready than that they are, but there's a good 40% of people who say they are. So that's a good sign for the industry.
So Alma, that is, sort of confirms a bit of the study that we just did. We just did a survey of, I don't know how many, 400 or so financial institutions, both domestic and international. And a lot of people were not ready. I mean, that was clear. That was, or had not done a lot. They were just basically said they were in the beginnings. If you go to the website, you can get our study on that, the results of that survey. And it was pretty interesting that people were not, and hadn't actually spent a lot of money on it either. And that even large institutions had spent, certainly less than $1 million on use of machine learning. So I think these results of this little mini survey are kind of consistent with that. Some, it's broken down obviously much more granularly there, but it's, how much have you done here? Some people have done a lot, then less, then down. And so this is kind of more, I think, consistent with the findings that we had as well.
Go to the beneficial ownership section. And Cassie, I wanted to tell you we had a question from the audience you might want to answer as you go through it. Next slide. Oh, there it is. Okay, it's someone asked what we think the value of the beneficial ownership registry is, given the exemptions for pooled investment vehicles. And I know that's the pooled investment vehicles and trusts are, I think, a big issue for the industry. But so keep that in mind as you go through this.
And Cassie, throw in there the exemption for nonprofits and charities as well.
Yeah. Cassie, are you on mute?
And these are all important issues to keep an eye on. And this is something that is going to be developing over the course of the next year. And there's going to be a lot of movement in this area because this is a brand new exercise for the U.S. government. And as Ellen said, this is a dramatic shift in our current landscape. And the Corporate Transparency Act is going to be shifting the burden of a lot of the collection of beneficial ownership information in a significant ways, and we don't know exactly how yet. So that's important to keep in mind. The sense of Congress in passing this was that this is a significant problem. There are 2 million corporations, according to Congress, that are set up under state laws every year, and that states basically don't have beneficial ownership information. And all of us who have worked in banks know that, and know and understand that collecting the beneficial ownership information, as people have been required to do since at least 2016 with the CDD rule for 25% owners, is difficult and is difficult for financial institutions. So the goal of this law is for there to be a federal FinCEN registry created in which beneficial ownership information for, quote, shell corporations or people who are under 25% owners of corporate limited liability, any sort of legal entity, will need to be filed in a federal registry. That's going to need to be filed by all existing companies within 2 years, and all newly created companies will have to be filing that over time. Once, of course, this actual registry is created, which we know will take some time. And I think Alma's going to want to chat about what she thinks about how long that may take. And reporting companies will also have periodic updating requirements. So everybody's going to have to file initially what their ownership is, 25% owners, with some exemptions we'll talk about in a minute, and then is going to update it annually. The annual updating is going to be studied by FinCEN and may be something that will have to come in shorter periods of time. And so creating this is a major enterprise, right? The federal government is going to have to create a really significant database. And Alma, I know you and I were chatting, what do you think is going to be involved in sort of just creating that?
Right. I mean, they'll have to have an RFP just for the technology. We all know how long it took to implement even BSA e-filing, which can be a tough, there's a lot of heavy lifting from a technology standpoint, not to mention the access standpoint. I do think it's interesting, and I wonder if it's a little snipey that state and local governments don't have access under the rule. It's also not clear how much access financial institutions are going to have, whether they have unfettered access, whether it has to be under special circumstances, how they'll get access. All of those questions have to be answered. And what do you do as a financial institution? One of those things to start thinking about, if the records you have don't match what's in the database, since the way it's written now, you have a year to update it. So are you going to have if financial institutions do have access, are they going to have a system to alert against there is a discrepancy so they can investigate and possibly file? One of those things where it's a good start, but I think there are a lot of questions, and this is not happening anytime soon.
And I think
Alma, wouldn't it also be
sorry, Deb.
possible for, depending upon the banks and how the rules come down, that some banks may choose to continue in their current process of obtaining information on beneficial owners for their own purposes, or they can file through the registry that will be set up. It'll be interesting to see how that works out, because in terms of the registry, there are certainly some limitations on banks' usage of that information if they've gotten it from the FinCEN registry. Cassie, I know you and I talked about that a lot.
We did.
And it's we know whether the government is going to validate that. Like, are they going to validate what's in the registry? And if they do, if it's not correct, are you allowed to, just rely on it because they've given it? If you look at what's in the Secretary of State, or even, if you look at what someone might have put into Dow Jones or any of those, or frankly, New York Stock Exchange filings, those aren't validated. So merely because someone tells the government something, is that enough? Will be the question to rely on that.
And these are really important questions. And I think that we don't know the answers to them, and we're going to have to find out, because it's going to have to be established. And the one thing that the conference report and the law makes clear is that financial institutions are not alleviated from the obligation to identify and verify beneficial owners of their legal entity customers. That obligation on a financial institution is not being eliminated by this law. The federal registry, however, is clearly being designed in a way to ease the burden. How it can be used to do that is unclear exactly, and Treasury has been directed to write new regulations to say how to bring CDD rule into conformance with this new statute, and what access the financial institutions will have and what reliance they're going to be allowed to make is going to have to be decided over the next year by Treasury through rulemaking processes that we all will have the opportunity to weigh in on. And it is also important to understand that this is being designed with significant confidentiality in the system and rules with respect to access. That's different from many other countries who are adopting similar rules. The whole beneficial ownership trend over the last 7-8 years or something, has been moving forward across the globe differently in different countries. And several countries have set up their beneficial ownership registry as a public database where just everybody has access. Other countries have set it up to be law enforcement, financial. There's different rules and there's different models out there. The US is clearly going on a non-public model, but how exactly it's going to work is going to be designed our own way and in our own systems. And there's definitely going to be confidentiality on the database. That's very clear from the rules.
Cassie, there's a question about whether will non-financial institutions be able to access the beneficial ownership database, not the way this rule is written now. And as I said, it's not entirely clear that financial institutions will have just a feed into it.
Right.
So I don't think it's planned right now to be opened up.
Right.
Well, a financial institution has to get consent from its customer to get the information from FinCEN under the regs, I believe, or under the law.
And the way it also looks like is that if there's a leak, the leak actually has a higher penalty than actually failing to file does. And so there clearly is a real interest in keeping the privacy relating to that information private, and so that is something that's there. So I think this is going to have to work its way through and how this actually, whether this is going to be the benefit to financial institutions that people hope it may be, we'll see. But Cassie, can you talk about those exemptions that are there and the reason what we think the reason is for some of those exemptions?
And there are a series of exemptions. A number of the exemptions actually track to the current CDD rule. I mean, currently under the FinCEN rule, there are categories of publicly traded companies, regulated companies, tax-exempt companies, investment banks, registered broker-dealers, securities clearing organizations, credit unions, et cetera. These are all institutions in which there's already information that's regulatory required about their ownership and control. These are things that would be somewhat duplicative to actually require the additional information here. They largely track what's currently in the FinCEN rules. There are two exemptions that are sort of new and not in the current FinCEN CDD rules that will have probably much broader ramifications. One is for sort of large institutions that employ more than 20 full-time employees in the United States, that filed U.S. federal tax returns in the prior year demonstrating at least $5 million in gross receipts or aggregate, and that operate out of a physical location in the United States. So physical U.S. businesses filing U.S. tax returns with U.S. employees over certain thresholds, again, this will be refined, will be exempt from filing. The other exemption that is not currently in any of the current CDD rules is for dormant entities, and that completely dormant entities, as defined, will also have an exemption available to them. Those are entities that are being defined as in existence for over a year, not engaged in an active business, not owned directly or indirectly by any foreign person. These are for U.S. dormant entities, have not had any change of ownership, have not had any send or receive funds more than $1,000, do not hold any assets. So these really have to be dormant, okay? They can't be new, they have to be in existence, they can't have assets, they can't have money, and they can't have foreign involvement. So there are some exemptions here, as I said. There are exemptions that, and they are carrying through, I think all of the current exemptions in the CDD rule and adding some new ones that will have to be better developed as we go through the regulatory process.
So, Cassie, the question is, this is just CDD. It is not KYC. So it doesn't obviate the need to know the customer. It obviates the need maybe to get certain information. But at the end of the day, there may be, need to do a lot more on some of these entities and just get information from the registry. And I think that's, we just want to be clear that this is not stop KYC. It may, relieve some of the CDD.
I think that that's really important, and I think that that's clear from what Congress has said, and also making sure. I mean, every institution knowing what they need to know about their customer to perform its own transaction monitoring is obviously an individual decision that banks are going to have to make.
Right. It doesn't stop a 312. It doesn't stop you from having to know, your foreign financial institution correspondent bank accounts, or know them more and understand more about them. It won't change any of that. But
it should give them more information available to be able to do these tasks. I mean, hopefully the goal is giving financial institutions more information, better access to the information. As we said, there's a lot of questions out there as to what happens when the information is contradictory to what you have. Your own KYC obligations will still apply, but this is intended at the end of the day to supplement that with a core level of base information that's standard across the states, that's not dependent on what New York does or California does or Texas does, standard core base information across the legal entity platform.
And Cassie, there was a question about what effect would this have on the CDD rule. So none right now, but FinCEN is supposed to do a study to see if the rule should be changed depending on how this beneficial ownership registry works in practice. So more to come. Another one of those things that's probably far out in the future.
All right, so I think we have another polling question.
We do. And we'd love to know what everybody would think would be the most difficult issue to potentially overcome related to the new beneficial ownership reporting requirements for your institution. Kristen, I'm not seeing the answers.
Not yet. We still have the old one.
There we go.
Well, maybe we'll come back to that polling question.
It's up. Can you see it, Cassie? It's up now.
Is it? I don't see it now.
So it says it's basically people who think yes, they are, that they are have the appropriate systems for this to focus on increased automation and emphasis on innovation. Is this one?
I think that's the last question.
Last one. That was the last one. Yeah. Sorry.
3. Survey 3.
Yeah.
Well, I can read it. So
go ahead, Alma. Go ahead.
No, go ahead.
No, it's just that it is. So the question is, what do you think the most difficult issue is to overcome? Cassie, do you want to go through these?
Okay, it's come up on my screen. Thank you. Most difficult issue to overcome for you regarding the beneficial ownership requirements. And it looks like there is a tie running between identifying the discrepancies between the FinCEN database and updating your current processes and procedures to align with the new CDD rule. And I think that that's probably right. I think those are a big tie, and they probably tie to each other too, right? In updating your database and identifying discrepancies are really going to be important, and resolving that information, and the users are looking at the right issues.
Well, I think because frankly on C, regardless of whether there's a new database or not, C is still a problem for many financial institutions to just update, their procedures for the CDD rule currently is enough, in doing periodic reviews. That's a lift for many institutions in any case. And then to have it on top of it, it's going to be a challenge. And
I think that's right. But hopefully, I think one of the goals of this is some of the other information in this act, some of the feedback that is going to be designed, some of the answers to questions and things, hopefully will also help to resolve some of the issues and make them less challenging going forward. At least that's my hope and optimism.
Great. All right. So now we're
Helen, were you going to talk about CTR and SAR reporting? I think so.
Sure.
Alma?
Deb, I think
So-
was
Go ahead,
Alma.
Ellen.
Sorry, no, Alma. You go ahead. I thought it was Deb.
No. So this is one that I think people will be very hopeful about, but I'm not entirely sure what will happen. They're just going to study streamlining and study thresholds. And I know from my experience, law enforcement likes a big fat database. They think there's stuff in there they can use, even if the financial institutions are pretty sure they're not filing very useful information because of the breadth of the rule or the imprecision of transaction monitoring. So I'd be interested to hear what you guys think about that. And then the CTR threshold, Ellen, you made a good point about that the other day. You know, the $10,000 was set in 1970 when that was real money, and it's not so much anymore. But on the other hand, people don't use cash so much anymore. So is that something that they'll, at the end of the day, assume say about where it is, because people are used to it and banks don't have to redo all of their systems for a different filing threshold. So not much actual information on this one.
No, although, you know, I had been talking to someone in Congress about this issue maybe a year ago, and they asked about the use, the change. And I said, who carries around, what business needs cash more than $10,000 per person, and who does this? And he said, there's one, casinos. Mm-hmm. And this is really something that the casinos are seeking, probably more than other businesses right now. And so that's because that, I don't know. Do any of the other panelists know people who walk around with more than $10,000?
No.
I mean, I'm sure there are. I just don't know them. So
Cannabis.
Yeah, because they can't get banked, probably. Because
Underbanked have more cash needs than the underbanked and the unbanked.
But $10,000 for the underbanked is a big number for them to have necessarily walking around with. And again, I don't know that it helps. Those numbers help, but I guess we'll see. There'll be a study done, right? There'll be a study done, and we'll see how that comes out. And when is that study supposed to be done?
We can go back to the wavy line, but then there'll be feedback to the financial institutions after the study as to how valuable the information that they've been giving is. So we do have studies and feedback.
Right, but I don't think that study is till 2025.
Don't hold your breath, folks. Don't hold your breath.
That's right. I think that study, or maybe the results of the study have to be in 2025. So we can meet you in a few years and talk about it again. Okay. Deb, are we going to the next one? Yes. So Deb.
So I'm going to talk a little bit about they've added in new penalties for a variety of actions, which are pretty extensive, as well as they've got a whole new whistleblower section. So first, I'm just going to touch on some of the new penalties that they've got, because some of them I think will be surprising. They've enacted, as part of the law, additional penalties for repeat violations. Somebody who has already violated a provision of the BSA before, they can get additional penalties of up to 3 times the profit gained or loss avoided by such person as a result of the violation, or 2 times the maximum penalty with respect to the violation. So that obviously is going to give them additional power to impose additional penalties and pain. They've also got, for certain egregious violations of the Bank Secrecy Act, it would be an automatic bar from an individual being able to serve on board of a U.S. financial institution, which really is sort of extraordinary. I mean, certainly the regulators along the years have taken actions to bar particular individuals from serving on bank boards or financial institution boards, but those are pretty specific in terms of the background and the challenge. This appears to be more of an automatic one. And for those who are barred, it's a 10-year bar that begins on the date on which the conviction or judgment as applicable with respect to the egregious violation is entered. So that certainly would be painful for someone. And I suspect if a bank is being looked at for civil or criminal penalties, one of the things as an attorney you're going to want to think through is might any of the board members be impacted by that? And if so, do you want to try to take a plea at a different level? It's just potential practical. Additionally, I think this is going to be a bit of a surprise. They now have a provision where they can force the return of profits and bonuses for anybody who's convicted of violating a provision or rule under the BSA. And this would be in addition to their fines, but basically it would be a clawback of their profits or their bonuses from the financial institution, usually within a 1-year period of time. I suspect this came about just because there certainly have been some stories of, some companies doing bad acts and then very large bonuses getting paid to their board members or their directors. And so I think that's probably some of the background on this. They also have increased penalties if somebody's concealing the source of assets in a monetary transaction. And somebody who is covered by that can get much higher fines than they've had before, and both in terms of forfeiture and money as well as time in jail. Equally interesting, and this is currently in effect, it came into effect with the law, is there's a whole new section on whistleblowing. And really, I think it was enacted to perhaps be similar to the SEC's whistleblowing program that I think has been in place for a couple of years. And I understand that one has, resulted in almost $700 million being paid out to whistleblowers. But basically, for somebody who is a whistleblower who voluntarily provides what's called original information to either their employer or to the Secretary of the Treasury or the AG, if it results in a large penalty, they have an option, but it's not the whistleblower's option, but they may get up to 30% of the value of the penalty. It will ultimately be in the discretion of the Treasury as to how much of the penalty that they get. And they did carve out from that figure things like forfeitures and the like. But this is I think this is going to be one of the more significant pieces of the law in terms of practical effect, because I think for anybody who does not have a very proactive internal process for allowing somebody to complain about somebody or say that something's going wrong, almost like an internal whistleblowing scenario, you're going to have to recognize that there are going to be there are increased incentives for people to whistleblow. And additionally, not surprisingly, there's provisions as well that prohibit you from, firing or harming the whistleblower. Now, under the Act, that prohibition in terms of impacting them is sort of broad, and they actually carve out from that provision institutions that are covered by the FDIC and certain credit unions. But the only reason they carve those out is because both of those sorts of entities are already subject to other laws that basically similarly prohibit you from having a retaliation against somebody who is whistleblowing. So I think this is going to be one of the things that's pretty significant. And as I mentioned, this is already in effect. So any questions on that?
So Deb, do you make it harder for regulators and law enforcement to sort of get agreement on some resolution of an issue or of an enforcement action?
It could possibly. It certainly will make it more complex. I mean, they're going to have to think through it. I mean, the SEC obviously has handled this, and there's been whistleblowers under Dodd-Frank Act for a while as well. But I think there's going to be more of a proactive back and forth. But I also think it's likely there's going to be more whistleblowers bringing forth information and actions as well, right?
No, but I'm even talking about the issues of the boards, with having the board members, knocked off a board for 10 years. Right, that now it's the board who is saying, "Hey, it's really going to impact me in some way."
Yeah, I think, for board members, they're going to have to think I think you would normally think pretty long and hard if you've got a potential issue that's significant anyway, but you're now going to have to think through it at a level of trying to make sure you're not ending up in a scenario where you might have board members or a board member that's blocked for 10 years and perhaps not end up in a whistleblower situation, where some of those penalties by law can potentially go to the whistleblower. So I do think there's going to be a strategy aspect to that for boards and for top compliance people to sort of think through what can we do to try to limit the likelihood of this happening to us pragmatically.
Okay, and so one of the last things we wanted to talk to you about are some of the enhancements that they made, and one in particular is the issue of de-risking. And so this has long been an issue when there is a class of, whether it's an industry or a type of customer, that where the banks have just said, this is just too much for me. It becomes too high a risk. We're just going to not deal with anyone who does this kind of business, or not deal with anyone who is, a PEP or of a certain kind of PEP, or not deal with anyone who is an embassy, for example, or a money transmitter, or digital currency business. It could be all different kinds of things. And that has actually become a problem for, frankly, the regulators don't really like it. It may be, again, the same sort of issue that we discussed before, where the main regulator or at the top level doesn't like it, but that on the exam side, they're like, well, why do you have these kind of clients and are you doing enough? And it's more administratively difficult. It costs more money to have a high risk client because you have to do more work for them. So there's going to be a study again on that, especially different humanitarian organizations have basically said the underbanked get hurt by this if the banks won't bank a money remitter, for example, or you won't, service that kind of organization. And so they think that what happens is it drives money. If the banks won't bank certain types of entities, then it's just driving that money underground and probably isn't helping law enforcement in any case and isn't helping, sort of shine a light on some of those transactions. So there is a request, there is a focus to now look at this and sort of take do some study once again and do a review to see if in fact de-risking is appropriate and how you can manage de-risking, how you can make it so it doesn't have a negative impact, and really study whether the impact on the unbanked and underbanked too. I think the government really does want to focus on and make sure that they get the right banking services and access to financial services. We then saw some other issues relating to, as Deb mentioned before, prohibition against the concealment of certain assets, a certain risky type of assets, and that there's going to be sort of more of a focus on the concealment aspect. Then also the issue for keeping, this is a very specific issue on keeping an account open. When the government says there's a problem on the account, the financial institution wants to close it out, but the government wants them to keep it because they want to watch where the money is going. I was a prosecutor, and I was actually for a while in charge of the forfeiture program in Southern District, and there were always those conversations we had with a financial institution as to whether can you keep it open so we can see. And so now there is a requirement that if law enforcement is going to do that, they have to put something in writing, and they have to really keep it clear that there is a safe harbor for keeping that open at a time, because there is from the bank's point of view, the bank or the financial institution is not in the business of keeping open accounts that could somehow, that create a risk for them. And so if they're going to do this and have, play ball with the law enforcement agency, they need to get written documentation of that. And then the other area that they have actually said are now covered are virtual currency companies are covered by this. Oh, we've got 5 more minutes left. And antiquities dealers. They specifically now are studying the art business, but left in antiquities, which some, they kind of go hand in hand in a way. But antiquities made it in, and art dealers sort of were able to at least keep this open for studying a little more.
And one thing on the antiquities, which is interesting, and I know obviously they'll come out with regs on it, but in terms of the scope, they're looking at it including advisors, consultants, or any other person who engages as a business in solicitation or the sale of antiquities. So it's a broad brush. So, just one question that came to my mind is, would that include museums, right?
Right.
They,
Oh,
right,
good move.
if they buy and sell, and then I know they're looking at whether they want to extend that as well to the dealers and arts, and we're going to do a separate analysis of that. But it looks like it's going to be pretty broad in terms of the effect.
And what is an
And I would also
what is art is sort of, is distinction. So that's the sorry, Cassie.
No, I was just going to add, I think it was interesting that, they codified FinCEN, they mostly codified FinCEN's prior guidance on virtual currency companies, which there were lots of people who alleged FinCEN had not had the authority to do that. So I think that looking at some of the existing FinCEN guidance in that area is important, because I think it's largely been codified by statute. So it's an important point.
So I just wanted to say one administrative thing. We're having fun, so we're going to go past 2 o'clock. If for those of you in the audience who can't stay with us, we will be sending out a recording, so you'll be able to see the end. But Ellen, I have to say this. There's nothing in this statute that talks about the rule for investment advisors, which has been pending in one form or another since 2002. And I don't know if that means they're going to finally push through the 2015 rule, or they've completely forgotten about it.
It is, or there's a really good lobby.
It is
Most likely.
It is a good point, Alma. I mean, as they are expanding the definition now, the art antiquities dealers, which they're bringing the law into conforming it theoretically with the European law that now covers art dealers and virtual currency companies, but they haven't expanded it in the way that they've been working on seemingly for a long time.
Yeah, I think because antiquities usually the issue is that it's owned by a particular country, right? And so where art may not, the art is individual, but I think they wanted to include it because there have been so many of these cases where they had returned the object to a particular country, and it was more belonging to the country and the people of that country, that I think they may have wanted to include it in here, or be able at least to make that distinction. All right, so Alma, I think we have one more polling question here, and we can then go from this to some questions from the audience if people can still stay on.
Yeah, so we're on poll number 4. We're on poll number 5. What topic are you most interested in hearing more about in a future webinar or podcast? I will tell you, we're planning a series of them, this group, because we do have a lot of fun talking about this stuff, in sort of 10 or 15 minute snippets, so that we can get, deep into it. And let's see what it says. Okay. Beneficial ownership and the streamlined SAR and CTR requirements that everyone is really hoping for. So, okay, great. We'll take that into account. And with the recording that's sent out, I think the slides will be included in that for folks who've been asking. Ellen and Deb, in the information sharing, somebody asked about issues specifically related to China in the new anti-money laundering statute. And this statute does talk about China very specifically, and it's probably going to be implemented in the correspondent banking subpoena rule as well. But I don't know if either or both of you want to talk about that. Deb?
Yeah, they did include a section both on China and also on, if I recall, authoritarian governments as well. And I think they're just going to be looking more into that in terms of, whether that raises particular risks and particular things that have to be addressed.
And in the information sharing, you won't be allowed to share with affiliates in China and Russia and some other areas. So if you are an U.S. affiliate of a Chinese institution, you won't be able to share your SARs with those institutions. So,
and then one thing we hadn't mentioned, and I just want to touch on it because it's just a little bit of a surprise. The law also includes provisions to expand how long the SEC has to take actions in terms of certain SEC violations, and basically it's increased the ability for them to go for disgorgement provisions in addition to penalties, and it's given up to, under certain circumstances, up to 10 years for those actions to be brought by the SEC for disgorgement. So I just want to note that, because if one is involved with an SEC case, and you might as well be aware that this certainly shifts some more power or some more ability to inflict damages on a company that's determined to have violated it. So I just wanted to mention that as well.
And there was one more. There was another question here about, it said education of employees that are part of the front line. That is, I mean, this is really important. It's important, I think, all the time for this everything. Is that, you know, the risk is owned by the front line, and the front line should be aware of the changes. They should certainly, you know, understand the differences. And I would absolutely encourage education of frontline employees on some of the, you know, on what's in here and what's most important to them, you know, to really do their job right and to be able to do their financial crime risk management properly. So with that, I think we're finished with our slides. We're finished with most of the presentation. If anyone has other questions that they want to ask, we can go through that. But we will be sending out this the deck to everybody so that people will get that. And, you know, stay tuned again for our I think we're calling coffee breaks, and they're 15 minutes. There'll be 15 minutes. And I guess if you do 4 of them, you get an hour's worth of CLEs. So that will be coming, and we'll go, you know, into more depth on some of these topics.
Yep.
So with that, if I don't see any more questions on this, I really do want to thank, you know, our friends at Winthrop Stimson, because they really are good friends to us, and we enjoy working with them so much. So I want to thank them for doing this with us and for, you know, coming together on this. And always my lovely friend Alma Angotti for working on these. And so anyway, that's it. That's it for today. Thank you all very much. I don't know if anyone else wants to add anything, but we're, you know, happy to do this and love the topic.
Thank you so much.
All right.
thanks, everybody.
I know.
Alma and Ellen, we really appreciated everybody from Guidehouse, and Pillsbury thoroughly enjoys doing this with you.
Indeed.